Trade secrets. A lot of you are probably hoping that you're never going to have to deal with a trade secret lawsuit, and I think that's a good hope for everyone because it's really a very expensive thing to have to defend your trade secrets when somebody makes off with a hard drive or with violating a non-compete where there are serious trade secrets at issue. This law, called the Defend Trade Secrets Act, is the first time that the federal government has gotten involved in authorizing companies to file lawsuits in federal court for misappropriation of trade secrets. So misappropriation of trade secrets can be anything from someone who knows something in their head that's secret of yours and tells somebody else the information. From that to actually taking a thumb drive or an external hard drive and just wholesale downloading and taking with them that information. And so the U.S. Congress said, this is starting to be an international issue with all this espionage of taking all of these trade secrets to benefit foreign companies and basically draining all the great resources from the United States and unfairly abroad. So basically they said, this is more than just the government needing to be involved. We are going to now amend the Economic Espionage Act, which allowed the federal government to prosecute people for this type of thing, and say now everybody is free to take this law and sue themselves in federal court. Now, practically, you still could sue in federal court for claims related to trade secret misappropriation, and you can also always bring a lawsuit in state court for trade secret misappropriation. So it's not like this, oh my gosh, the Red Sea is parting and now we have this right that we didn't have before. It's just, it's federal court, it's kind of technical. Sometimes you'd rather be in federal court. And so that's why the lawyers are, kind of excited and geeking out about the possibilities now that we can be in federal court. But I'm not going to talk about that today. I'm going to be basically talking about just a high level, what is the law, and then what does it mean to you? Because there's very specific things that you do need to know, and probably everyone in this room is going to have to look at what they are currently doing and make some changes to it if you haven't already. Now, as I just described, it allows for a federal private right of action, meaning that we can now go into federal court and sue for misappropriation. Okay, I've explained that. It also contains a provision allowing for seizure of materials. We think of the federal government as seizing a lot of things, They like to seize. Well, now we can be the beneficiaries of these seizures by filing the lawsuit and saying, hey, go, feds, go and take something for us and let us be the seizers. And then lastly, there's some immunity language that the federal government wants us all to have in our agreements that we need to disclose to people in order to fully take advantage of the remedies allowed in this law. So what's a private right of action? Injunctive relief. I can get a TRO. I can get a restraining order. I can get actual damages. I can get unjust enrichment. That just means if you do something and it's using my trade secrets, that's not fair. You've gotten rich off my ideas. I can get money for that. I can get a royalty. They allow you to get a reasonable royalty from misappropriation. Like, okay, for everything you sell based on my trade secrets, I get $1 or I get $1,000 or whatever. They also have exemplary damages, also called punitive damages, attorney's fees, etc. So that's what the private right of action is about. And then the seizure, of course, is a very powerful thing where you're allowed to have the federal law enforcement agents actually go in and take stuff. It is applicable in other areas, like remember the copyright infringement? Remember when back in the days of the VCRs, you had all these pirated videos and the feds would go into these mom and pop shops that have all these pirated videos and basically take it all, seize it? I don't know, I worked on it in law school, it was really fun. Anyway, it's that kind of thing, where they actually go in. Now, it's a very powerful thing, right? And so there are a lot of things written into the law to allow for people who are unjustly seized to go back into court and basically get their pound of flesh. Is that too much with Uncle Sam with a gun? I'm sorry. Didn't mean to be political on that. Okay, so now, finally, what is the real takeaway for us in this environment of what we're talking about today in employment law? there are immunities in this law, okay? Immunities that encourage employees to go to law enforcement officials, and not just federal law enforcement officials, state law enforcement officials, and to attorneys. If you take a trade secret of an employer and you go to one of those entities, including a private attorney, and that is to basically report or investigate suspected violations of law, you cannot be prosecuted or sued, okay? That's what the law says. Okay, big deal, right? Why is Scott telling you this? The reason is because they want you to tell all of your employees about this in writing, okay? And how are they going to get you to do this? Well, what they're basically they're going to say is, well, okay, here are the immunities before I tell you how they're going to do it. Basically, if you report it to the government, you're okay. If you report it to an attorney to investigate, it's okay. And if you file a lawsuit for retaliation for reporting something, you can basically disclose the trade secrets to a court. Okay, so how are they going to get you to do it? Well, they're going to make you put it into any contract or agreement with an employee that governs the use of a trade secret or other confidential information. Any non-disclosure agreement, in other words. And they've defined employee to include independent contractors. How many NDAs do you have with third parties? All of those are now subject to this law. So now, you're not going to get fined if you don't do it, okay? You're not going to get put behind bars or have anything seized if you don't do it. But if you don't do it, you're not going to be able to use some of the best parts of this law if you ever do have to go into court. So basically they're saying, if you don't do what we want you to do, then if you sue under this law, you're not going to be able to get punitive damages, and you're not going to be able to get attorney's fees because you didn't do what we're saying that you need to do. Okay? Now, there's another thing that you can do. You don't have to put it in the agreement itself if you have a policy document. Okay? What is a policy document? A policy document that sets forth your reporting policy for a suspected violation of law. Now, a lot of big companies, of course, have their, I'm sure, have their compliance, code of conduct, and has all kinds of hotlines and all that kind of stuff. They're set, right? They've got their policy document that tells employees what to do if they have a concern about a legal violation going on in their company, right? They're going to be allowed to just say, hey, policy document in their agreement, okay? But if you don't have a policy that deals with reports of suspected violations of law, number one, consider whether you should get one because, you probably want to know if people are violating the law at your company, probably. And then secondly, it's kind of the language that you're going to need to add. It's like a paragraph or two. It's a lot of information about immunities that employees have. And I'm not that big a fan about putting it in my NDAs. Because what you're basically saying to your employee in an NDA is, you're not going to use my trade secrets, right? You promise that you're not going to use my trade secrets. You're not going to disclose them to a future employer. You're going to keep it confidential. Oh, but by the way, you have all these rights to disclose our trade secrets to the government, to a private attorney if you want to sue us. I mean, a lot of information, like, you might not want to plant that seed, right? So I think that every employer just needs to look at what they're doing, right? What kind of agreements that they have, what kind of people that they're signing these agreements with, is planting the seed of concern. Because it's obviously easier to just dump it into an agreement and forget about it than to create a policy document or to cross-reference a policy document. What if the employee doesn't get the policy document? All of that kind of stuff. So I think it's going to be a case-by-case determination because a lot of my clients have already said, well, what should I do? I said, well, it really depends. Let's talk about what you do. But I think you should do it because, if you ever get into that situation where somebody's taking your stuff, you want to be able to come down like a ton of bricks on these people, right? And this law is a powerful law. It's the most powerful law out there, in my view, now for employers to really go after someone when, you hope it never happens, but when somebody steals something from you. And by the way, I mean, a lot of things can happen when somebody takes a thumb drive, right? It's not always going to be someone just, who's intentionally stealing stuff. But it really is a recognition that this is getting more and more common, that information is getting more and more easy to take and steal, just put it on a thumb drive. And this is kind of not related to this law, but if you don't have a procedure to make sure that employees have returned everything, all of their confidential information, you really should, condition it on receipt of severance if they're going to receive severance. Make them certify, at least in the NDA, if not when they're leaving the company, that they have returned all that information, and maybe even have IT involved and looking at their computers to make sure that there's no suspicious activity, because it's very easy to do, very easy to do. Okay, so we talked about the consequences of failure to provide notice. Importantly, this applies to the immunity requirements and the consequences of failure to provide the notice applies to all contracts entered into as of the effective date of the law, the day after the effective date of the law, so after May 11th, 2016. So if you're signing new agreements after May 11th, 2016, you should have it in there. A lot of people ask, well, what about current agreements? Do I have to have everybody sign new agreements company-wide? My answer is I do not believe so, because it says this applies to contracts and agreements that are entered into or updated after May 11th. So to me, you should be able to sue under the DTSA for past agreements without having to update them and get the full remedies. But obviously that hasn't been tested in court yet. Is somebody going to say, well, you didn't have the language, so make a technical argument? Possibly. But that's where we are right now. So what do? This is just a review. I think I've talked about it all now. But number one, look at any agreement, and it could be in an offer letter, but it certainly is usually in an NDA. People call it a confidentiality agreement or a PIIA. All of those agreements and return of property agreements, and put the language in those things, including your NDAs with third parties. Okay? And remember, consider whether you have that policy document that I talked about before, and whether it's better to cross-reference that in your agreement. So either way, just to make sure, your agreements need to be changed one way or the other. Either it's going to include all that language in it, or it's going to cross-reference your policy document that talks about how to report violations of law. So either way, you're amending your agreements. It's just how you're going to amend your agreements. Okay, well, that's the program. I got a minute left, so I can give a minute back to Ted. Ted ran out of time. Yes, Courtney. Okay, so the question is, what about in your departure agreements, like a severance agreement? Do you mean just the agreement that they have returned everything, or the DTSA language? No, I don't think that you, well, okay, so the idea must be that in your severance agreements, you've got a statement that you'll continue to comply with your confidentiality agreements. I think that if it's an old confidentiality agreement, that would be kind of like a belt and suspenders thing to put it in your severance agreement and to let them know that they have the right. Yeah, I probably would do that. That's a pretty good idea. Thanks. Thanks for that. Yeah. Send me a bill. Thank you. So the idea would just be like, if I have a severance agreement that says you agree that you are going to continue to comply with your NDA, right? And the NDA is the old NDA that doesn't have the new language in it, then you're basically making an agreement relating to non-disclosures in a way that if you want to make sure that somebody doesn't have a technical argument that that you don't get to use all those remedies in the DTSA, that you just put it in the severance agreement that says you do have the right to disclose trade secrets to government officials. I think that's probably a good idea, and I will compensate Courtney for that idea. Thank you. All right, well, we will all be here, for as long as anybody has questions. Thank you so much. If you have any feedback also about what you liked about the program, what you didn't like, the facilities, please let us know, and thank you very much for coming, everybody.